శ్రావణ్ శ్రావణ్
చెప్పండి సార్.
అదే ఆడిబుల్ గా ఉంది కదా?
ఎస్ సార్, క్లియర్ సార్.
ఆడియో ఆడిబుల్ గా ఉంది, ఇబ్బంది లేదు. ఓకే
ఎస్ సార్, ఎస్ సార్.
సార్ సత్యనారాయణ సార్, గుడ్ మార్నింగ్ సార్. సార్ మైక్ ఆఫ్ లో ఉంది సార్, మీది మ్యూట్ లో ఉంది సార్ మైక్.
అంతా అయిపోయిందా సార్? ఇబ్బంది లేదు కదా? అంతా ప్రిపరేషన్ అంతా
అంతే సార్, ఇంకొక 15 మినిట్స్ వన్స్ కిక్ స్టార్ట్ స్మూత్ గా రన్ అయిపోతాయి సార్.
అట్లాగే, ఓకే సార్.
అంటే ఏదైనా అక్కడక్కడ లాగిన్ రిలేటెడ్ ఇష్యూస్ రావచ్చు సార్, అదొక్కటే కొంచెం ప్లాన్ చేసుకుంటున్నాం మేము కూడా.
లాగిన్ ఇష్యూస్ ఎవరికైనా ఇబ్బంది వచ్చి ఫోన్ చేసి మనకి మెసేజ్లు పంపిస్తే అటెండ్ కావాలి. అది
అంతే సార్, అంతే సార్.
అది మరి ఎవరికైనా
మీ బ్రాంచ్ నుంచి సార్
అది ఎవరికైనా అప్పచెప్పకపోయినావా? అప్పచెప్పు.
అది ఆల్రెడీ మా సెక్రటరీ, మా బ్రాంచ్ ఏవో చూసుకుంటాడు సార్ అది.
ఓకే, అట్లాగే.
జనరల్ గా తనే అడ్రస్ చేస్తారు మెంబర్స్ అందరినీ. జస్ట్ వాట్సాప్ లో మనకి మెసేజ్ కానీ పెట్టేస్తారంటే, పేరు పెట్టేసి నాకు ఉందని చెప్పారంటే ఆటోమేటిక్ గా మా ఏవో ఫాలో అప్ చేసుకుంటాడు సార్.
ఓకే సార్, అట్లాగే.
సుదర్శన్ రైట్ సార్, గుడ్ మార్నింగ్ సార్. సార్ ఇప్పుడే ఫ్యాకల్టీ గారితో మాట్లాడాను, గెస్ట్ ఆఫ్ ఆనర్ తో కూడా మాట్లాడాను సార్. ఒక 5-10 మినిట్స్ లో జాయిన్ అయిపోతా అన్నారు సార్. ఫోన్ చేస్తాను సార్ నేను.
టైం కూడా ఉంది.
టైం ఉంది సార్, జస్ట్ అంటే కొద్దిగా లాగిన్ ఇష్యూస్ ఏమైనా వస్తాయేమో చీఫ్ గెస్ట్ గారికి. సార్కి జూమ్ అలవాటు ఉంది కానీ రిజిస్ట్రేషన్స్ ఇవన్నీ డిఫరెంట్ కదా సార్ ఉంది ప్రొసీజర్.
ఎవరికి సార్?
నేను కోఆర్డినేట్ చేసుకుంటాను సార్. ఓకే సార్. Dear members, our Chief Guest Senthil Kumar Sir, Deputy Commissioner of Income Tax, has also joined with us. Good morning, sir. Welcome to the session. Sir, am I audible, sir? Sir, am I audible, sir?
Yes, sir.
Yeah.
Sir, నా వాయిస్ వినపడుతుంది కదా?
ఓకే అండి.
Arun.
ఓకే, థ్యాంక్ యూ.
హలో. ఆహా. Mastan sir, good morning sir.
Good morning, Vamsi. Good morning to all. Good morning, Madal Satran Garu,
Good
Rajendra
morning, sir.
Prasad Garu.
Good morning, sir.
Namaste,
Good
sir.
morning to all. Namaskaram.
Sir, our chief guest Senthil Kumar sir has also joined with us, sir.
Okay.
Right now with us.
Good morning, Senthil Kumar sir. Welcome to this program. This is Chanamastan, executive member of Ongole and Nellore branch.
Senthil sir, is it audible, sir? Hello. Senthil sir, am I audible? Sir, just now our faculty Abhishek Murli sir also has joined us. Welcome sir. Welcome to today's seminar, sir.
Good morning, sir.
Welcome, Abhishek. Abhishek, good morning.
Abhishek, sir, you are in mute, sir. I think it's a photo.
It's a photo, sir. I think it is
It is
a
a
photo.
photo. It's not video.
Yeah.
Am I audible?
Sir, audible,
You
sir.
are audible. You are audible.
Hey,
morning, sir.
welcome, Abhishek.
Good morning to all. I
Good
apologize,
morning, sir.
some internet connectivity issues are there, so that is why it got a little late.
Good morning, sir.
Good morning, sir. How are you?
Fine, sir.
Welcome, Dr. Abhishek.
Namaskar, brother.
Namaskar, everything
How are
good?
you?
Good, Abhishek. Everything good.
Phone నుంచి సార్. Senthil Kumar sir, am I audible, sir?
ఫోన్ చేయండి వంశీ గారు.
In case I get disconnected or something, you
No, sir. Sir is already connected. Hello. Senthil sir. Yeah. Hello. Good morning, sir. Senthil sir. Am I audible? I think there was a network connection issue, members. Take another 5 minutes. After 5 minutes, we'll straight away start with the program.
Okay.
Yes. Sir, you are not audible, sir. Senthil sir, you are not audible. Shravan?
సార్ లాగిన్ అయిన ఐడిలోనే మైక్ లేదు సార్. ఇంకో 2 ఐడీలు ఉన్నాయి, వాటిలో మైక్ ఉంది.
అది కాదులే, ఈ ఐడిలో మైక్ లేదా?
ఈ ఐడిలో మైక్ లేదు సార్. ఎప్పుడు వీడియో వచ్చే ఐడిలో మైక్ లేదు.
ఓకే ఓకే సార్, హెడ్ ఫోన్స్ లేకుండా ట్రై చేయమని చెప్తాలే సార్ ఒకసారి.
ఓకే సార్.
సార్ మీరు అన్మ్యూట్ లో ఉంది సార్ మీ ఒకసారి మ్యూట్ లో ఉంది అన్మ్యూట్ చేయండి సార్ ఒకసారి.
వంశీ గారు ఇప్పుడు is it okay?
ఎస్ సార్
Fine, fine.
గ్రేట్ సార్.
I'm sorry for the delay.
నో ప్రాబ్లం సార్, వీఆర్ ఆన్ టైమ్.
Right.
అరుణ్,
Yes, sir.
it's already 11:03, so I
Okay,
think
sir.
we can start the session.
Okay, sir. Good morning, members. Welcome to today's webinar on Vivad Se Viswas Scheme 2020. On behalf of Nellore branch of SIRC of ICI, I welcome today's guest of honor, CA T. Chinnamastan, sir, Regional Council member. And I welcome today's chief guest, Dr. Sindhil Kumar, sir, Deputy Commissioner of Income Tax, Nellore. And I also welcome today's faculty, CA Abhishek Murli, sir, who is current secretary of SIRC of ICI. Thank you, sir. And I also welcome chairman of Ongole branch, CA M. Satyanarayan, sir, and chairman of Tirupati branch, CA P. Sudarshanam Naidu, sir, to this webinar. And before proceeding to the webinar, I request our branch AO to play our institute's motto song.
I request the members to please raise. Thank you.
य एष सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्मिमाणः निर्मिमाणः तदेव शुक्रं तदेव शुक्रब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्वैता 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 एतद्वैता.
Thank you, sir. So now I request our Nellore branch chairman, C.I. Vamsi Krishna, sir, to speak on this occasion.
Thank you, Arun. On behalf of the managing committees of Nellore branch, Ongole branch and Tirupati branch, I welcome all the members for today's webinar on Vivad Se Viswas scheme. Good morning to all. On behalf of everyone, let me thank and also welcome our chief guest, Deputy Commissioner of Income Tax, Mr. Sindhil Kumar Garu, to our webinar. I would also like to welcome today's faculty and regional council member and also the secretary of SIRC, Mr. Abhishek Murli Garu, for this program. I would also thank our chief guest, a guest of honor and a regional council member, ex officio member of Nellore and Ongole branch, Chinnamastan Garu, for making this event possible. This scheme is an attempt to release 9.3 trillion of amount blocked in approximately 4,83,000 appeals pending at various appellate forums. So you can understand what is the amount of funds that were blocked in this appeal. So the department is clearly intended to liquidate this amount to some extent by giving an option to all the SSCs to avail this Vivad Se Viswas scheme. Dear members, as the due date for filing Form 1 application to avail the Vivad Se Viswas scheme benefit is approaching, it is time to go through the provisions of the scheme once again, so that the current guidance can be given. So this program, I think this program will give a proper guidelines to all our members and in turn help our clients. I also hope this session will help us clarify all our doubts that arise while filing the form. Instead of waiting till the last date, I request the members to file the Form 1 at the earliest, as we are being chased by various deadlines like non-tax audit returns, tax audit returns, GST filings, and GST 9C, 18-19 year. So I request the members to complete this procedure at the earliest. I would also like to remind the members to please check whether your membership and COP fee is paid for the year 1920. If not, please, the deadline is 15th December. So if any member has forgot to pay, I request them to get it done at the earliest. Because during the bank audit session, we also discussed the various impacts that are going to be faced by the members if the membership fees was not paid in time. Further, I also request the members to please go through SSP portal and cross-check all your details once. Since a lot of convergence of softwares happened in the institute, I request the members to go, please log in SSP portal and check all your details. Ensure that declaration form has been filed and your mobile number is validated. Lastly, I would like to remind that Segaram program of SIRC of ICI, that is 52nd Regional Conference, will be from 10th December to 13th December. A wide variety of programs are being organized by the SIRC Regional Council in relation to direct taxes, indirect taxes, FEMA and other areas, how to improve your communication skills other. So I request the members of all the 3 branches to kindly participate in this program and make it a grand success. Everyone in this meeting, including me, is waiting to be here from our guests and faculty. So without much further delay, I request our branch secretary, Mr. Arun Kumar, to please carry on the proceedings. Thank you, members.
Thank you, sir. Thank you very much. Now I request our guest of honor, CA T. Chinnamasan sir, to give his remarks.
Very good morning, everyone. I hope my voice is clear.
Yes, sir.
Yeah, thank you. Respected Chief Guest of the day, Dr. C.A. Senthil Kumar, IRS, Deputy Commissioner of Income Tax, Nellore Circle, and my council colleague and Secretary of SIRC, and today's speaker, Dr. C.A. Abhishek Murli, Chairmen of and Office Bearers and MC members of the 3 branches, Nellore, Ongole, and Tirupati. My dear members who joined this virtual CP meetings on the Viswas scheme, once again, good morning and welcome to you all for this meeting. Before coming to this topic, let me remember and recall, since the independence, our senior chartered accountants seen several voluntary disclosures, income schemes like VDAS. In the first one is the 1951 and 1965, 1975, and few amenity schemes by circulars in 1985, and the VDAS scheme in 1997, and lastly in the 2016 also. Looking these amenity schemes for every 10 to 15 years, and it's going to be a good opportunity from the point of assessee. It is coming to their rescue, as the income has not been disclosed at the time when they earned. And from the CA paternity point of view, we can ask those assessees in the right direction to utilize this opportunity, which has come as blessing in disuse. Though the topic Vivad and say Viswas scheme is not exactly as I have referred now, still it provides more kind of relief to every taxpayer in terms of the compliance as well as in the terms of monetary soups. Right from the day it was introduced in the form of bill in the parliament, it is getting extension all the times, and to my information, it is now extended to 31st March 2021, and the CBDT has been issuing more FAQs. Even I saw that yesterday one website, another 34 FAQs released in addition to the 55 FAQs which was released in the month of April 20. So anyway, the speakers, the CA Abhishek Murli, who will take through these various issues involved in the scheme in the lucid way, and one representatives from the Income Tax Department side, Dr. Senthil Kumar Garu, IRS, is here to add value the program and enlighten our members to pros and consequences of the schemes. Dear members, if you observe this inaugural program, is the rarest we can find the two doctorates, and that one is the Dr. Senthil Kumar sir, and the other is Abhishek Murli. So it's very rare that we got that three branches at inaugural time, two doctorates persons. I believe this session will definitely help to the members to advise the better way to client who get this benefit. Members, coming to this updates from the institute side, that first one is the MEF updates. It's going on scrutinizing all the MEF applications. I think by this month end, we will get that provisional list of the auditors for the 2021. And it's in a position to PDC is asking that income tax returns of the partners and the members. So might be you will receive that mails to get this information. And as the chairman of Nellore Branch Express Regional Conference, it is going on from 10th of this month to 13th. It's a good program. I request all the members from the Tirupati, Nellore and Ongole register for these programs. It's our region program. You should encourage these programs. I sincerely appreciate three branches for coordinating and organizing this virtual meeting for these members. And my special thanks to Dr. C.A. Senthil Kumar sir, IRS Deputy Commissioner, to join this program as a chief guest. I thank for each one of you for giving opportunity, and my best wishes. Stay home, stay safe. Thank you so much.
Thank you, sir. Arun, are you there?
Meet.
Arun, are you there? So, hello, Arun.
Okay, sorry, కొంచెం internet trouble.
Okay.
Thank you, sir. Thank you very much. Now I request Ongole Branch Chairman CAM Satyanarayan sir to introduce our chief guest, Dr. Senthil Kumar sir.
Good morning to the chief guest, Dr. S.K. Senthil Kumar, IRS, ex officio of our branch CA, T. Chinmasan Garu. Today's speaker, Dr. C.A. Abhishek Murli, Secretary of SIRC, Chairmen of Nellore branch and Tirupati branches, and all other fellow members in the virtual seminar. I feel it my privilege to introduce today's chief guest, Dr. S.K. Senthil Kumar, IRS. Dr. Senthil Kumar, IRS, was born in the year 1979 at Saman-Kuttu village in Tirupur district of Tamil Nadu. In this village, the population is less than 100. He studied up to 5th class in the same village. From 6th to 10th class, he studied in a village called Kunnaturu, 3 kilometers from his village, where he went to school by walk from his village. He studied degree in BSc in Erode district from the year 1996 to 1999. Later, he shifted to Chennai to study PG with an aim to prepare for civil services. He joined in MA Public Administration in a Presidency College. He got gold medal in PG. This Presidency College is known to everybody in Chennai. Further, he studied MPhil in Public Administration. In the year 2003, his father was expired and the entire family burden is shifted to him, even though he has 2 elder brothers. His both parents are illiterates. His parents have motivated him to achieve highest post. Later, he appeared for UGC exam for national eligibility test in public administration and passed out with top rank. He got stipend for doing PhD. He was awarded with the designation of doctor for doing PhD in public administration. In the year 2008, he appeared for public service exam of Tamil Nadu Group 1 and got qualified and got the post of deputy registrar. In the year 2009, he joined in the Indian Railway Accounts Service. In the year 2011, he qualified as an IRS of 65th batch. In the year 2013, he married and blessed with two children. His marriage was his love marriage. Initially, he joined as an Associate Commissioner of Income Tax on 19th December 2011, posted at Guntur Circle 1. Later, he transferred to Vijayawada Circle 1. Then he promoted as a Deputy Commissioner, Investigation and posted at Vijayawada. Later, he transferred as a Deputy Commissioner, Circle 2-1 at Vijayawada. At present, he is a Deputy Commissioner of Income Tax, Nellore Circle. Shortly, he will become as a Joint Commissioner of Income Tax. With this small introduction, I am introducing Dr. S.K. Senthil Kumar Garu, IRS, to the seminar. Thanks for your time. Thank you, one and all.
Thank you, sir. Now I request Dr. Senthil Kumar sir to speak on this occasion.
Thank you, Mr. Arun. Today's guest of honor, Sri T. Chinnamastan Garu. Today's faculty, Dr. Abhishek Murali Garu. Participants from Learned Chartered Accountants Fraternity of Nellore, Ongole and Tirupati. Participants from Learned Income Tax Practitioners Fraternity from Ongole, Nellore and Tirupati. All the participants of this session and honorable taxpayers who are participating in this session. Good morning to you all. I'm honored and privileged to participate in this brainstorming session on Vivad se Viswas scheme 2020. Further, on behalf of Income Tax Department, Andhra Pradesh and Telangana region, Office of Principal CIT, Tirupati Charge, Tirupati, and Office of Joint Commissioner of Income Tax, Nellore Range, Nellore, I would like to congratulate the managing committee members of Nellore, Tirupati, and Ongole branches of SIRC of ICAI for arranging this wonderful session on right time. As we all know, Dr. Abhishek Murali Garu is an eminent speaker and hope that he is ready to enlighten us with the full facts and procedures about this Vivad se Viswas scheme. I don't want to take much of his time. However, I would like to touch upon the basic features about this scheme. The main objectives of this Vivad se Viswas scheme is to reduce income tax pending litigations. As rightly pointed out by Mr. Vamsi, as on today, nearly 4.83 lakh litigations are pending from all the forums, including CIT appeals. And this scheme is going to give a one-time settlement for all the pending litigations. And second objective being to generate timely revenues for Government of India. So an authentic newspaper report says, as on November 19th, 2020, so far this scheme has earned 74,300 crores so far under this scheme. And the third objective being to assist the taxpayers to end their tax disputes by paying disputed tax and getting relief in the form of waiver from interest, penalty, and prosecution. So these are the main three objectives of this scheme. Now we'll see about legal background of this scheme. Originally, as our today's guest of honor has rightly pointed out, the bill was introduced in Finance Bill 2020 on 5th February 2020 by our Honorable FM, and it became Act on 17/3/2020 by getting Honorable President's assent. Considering the pandemic situation, the scheme has suitably extended time and again. The latest notification about this scheme came on 27/2020 as notified 85/2020, in which the last date for filing under any taxpayer under this scheme is 31/12/2020, and payment on this scheme is 31/3/2021 without having any interest payment. So the Gazette notification clearly says that as on today, The last date for filing this scheme is 31/12/2020, and last date for payment without any interest is 31/3/2021. And consequent to that, series of circulars have been issued by CBDT, and latest being the circular 21/2020 on 4th December 2020 with various FAQs. As so many queries have been raised by various fraternities, including tax assessees, the CBDT is giving various circulars in the form of FAQs, and it is addressing all the queries. Now we'll see who are the eligible assessees who can opt for this Vivad Se Viswas scheme. Assessees whose appeals, writs or SLP or arbitration filed on or before 31st January 2020, filed by even department or filed by the assessee. So as on date 31/1/2020, if anyone's appeal is pending, either appeal filed by the department or the assessee, those assessees are eligible under this scheme. Not only that, orders for which time for filing appeal has not expired on 31/1/2020. Suppose there is a situation, assessee would have received his assessment order on 3rd January 2020 for filing his appeal within 30 days from the receipt of the order. So he will be having a time up to 2nd February 2020. So he is also eligible under this scheme. And cases pending before dispute resolution panel, DRP also, and 263, 264 cases pending before principal CITs. Disputes where payment has already been made shall also eligible. So sometimes there is a situation, disputes are pending in which payment would have been paid by the assessee, but even though that assessee is eligible under this scheme. So if any assessee before opting this scheme, he had paid more taxes than the arrived tax in the scheme, he will be given refund also. What are the disputes which will cover under this scheme? Appeal, writ, SLP, arbitration could be against any disputed tax, including interest, penalty in relation to an assessment or a reassessment order. Disputed interest, penalty, fee where there is no disputed tax. Sometimes there is no dispute on the tax, but there will be a dispute on interest, penalty or fee also. Even tedious disputes, TCS disputes, sometimes assessee would have received enhancement notice also from CIT appeals or some various appellate forums. Even those cases are also eligible under this scheme. So by seeing who are eligible, there are some non-eligible cases also. Such cases, if disputed tax in a year is above 5 crore, those cases are not eligible under this scheme. Prosecution initiated cases. Suppose in any one of the cases already prosecution has been initiated by the authorities, then those cases are not eligible to come under this scheme. Cases involving undisclosed foreign income and assets, and cases completed on the basis of information received from foreign jurisdiction. Suppose assessment is completed on the basis of the information received from the foreign agencies for having foreign jurisdiction, those cases are not eligible under this scheme. Again, cases notified under special courts, Coffee Posa Act, NDPS Act, Prevention of Corruption Act, PMLA Act, PBPT Act. So these cases which falls under these various acts are not eligible under this scheme. Very important dates as already discussed. As on today, for filing form number 1 to opt for this scheme is 31/12/2020. For payment of taxes under this scheme without any interest is 31/3/2021. Now we will discuss about benefits. Okay, if any assessee is opting this scheme, what are the benefits he will get? As we already discussed, all appeals, all pending litigations will be withdrawn by the department as well as by the assessee. So the litigation will come to a concluding point through this one-time settlement scheme. And assessee will get immunity from interest, penalty, and prosecution. If any excess payment also made by the assessee before he opts for the scheme or while opting for the scheme, refund will be given, but there will be no interest on it. Before I conclude, I would like to enlighten about the measures taken by our income tax department to facilitate the potential taxpayers or their authorized representatives for smoothing the entire process for achieving the objectives of the scheme in coordination with the assessee. Our respected principal CCIT, Andhra Pradesh and TS region, Honorable Sri J. Mohabatra Sir has constituted committees to resolve all the queries which arise in due course. Our respected Principal CIT Sri Morampudi Anil Kumar IRS, being the committee chairperson for Andhra Pradesh region, and SAR's regular office is located at Vijayawada, SAR has in turn constituted subcommittees office-wise to attend all the queries that come in due course for the assessees or for the authorized representatives. So we are available to you 24/7 in all offices. You can ask your queries and get it clarified. I take this opportunity to request all the authorized representatives in the form of CAs or income tax practitioners, or few assessees are already joined the meeting, to opt for this scheme, because this scheme provides you a complete one-time settlement in all pending litigated cases. The potential cases also from the department side we have identified the potential cases being reopened cases. Suppose the cases which has been reopened due to some other side information or some audit objections. Suppose a case pertaining to assessment year 12-13 or 13-14 reopened cases, as on today, the interest will be more than the tax, sometimes double or triple times than the original tax. As this Vivad scheme, Vivad Viswas scheme is giving waiver from the interest and thereby penalty also, all reopened cases are very eligible cases for this scheme. And as all of you are aware about penny stock cases, there are penny stock cases wherein huge assessments have been completed, and those cases are very well fit cases under this scheme. And the disputes pertaining to loss and depreciation, and you can calculate MAT or loss or depreciation, which is going to be a unabsorbed depreciation or unabsorbed loss in near future. Those cases also very well fit into this scheme. And there is an exclusive provision given in the Vivad Se Viswas Act under Rule 9 and 10, which clearly and categorically states about the method of computation in all loss cases and MAT credit cases. So those cases are also very, very potential cases. And I believe our eminent speaker, Sri Abhishek Murali Garu, will cover all the other important facts and process of this entire Vivad Se Viswas scheme without wasting time, by thanking all managing committee members for providing me this opportunity. I conclude my part. Thank you.
Thank you, sir.
Thank you very much, sir. Thank you for your brief on Vivad. Branch Chairman P. Sudarshanam Naidu, sir, to introduce our Abhishek Murali, sir.
Sir, Sudarshanam, sir, you have to unmute your mic.
Now audible, sir.
Yes,
Om
sir.
Namo Venkatesaya. On behalf of Tripti branch of SRS of ICI, I would like to introduce our today's speaker, Dr. C.A. Abhishek Murli Profile. It's my immense pleasure to introduce today's speaker profile. Dr. C.A. Abhishek Murli is a practicing chartered accountant at Chennai. He is currently the partner of Measures Victor, Grace and Co-Chartered Accountants and Secretary of SARC of ICI for the year 2021. He is also an All India first rank holder in the SEMA strategy examinations and All India 17th rank in the SEMA final examinations. He also secured the All India 5th rank in the international taxation examinations conducted by CIOT. Dr. C. Abhishek Murali is the youngest elected regional council member of the Southern India Regional Council of the Institute of Chartered Accountants of India by securing the highest number of votes from Tamil Nadu. He has the honor of being the youngest elected secretary of the SARC of ICI. He is an expert in direct taxation, international taxation, litigation appeals, valuations, due diligence, and M&A. Dr. C. Abhishek Murali has conducted and spoken at more than 500 seminars on direct taxes in 1 year. During the COVID lockdown period, Dr. C. Abhishek Murali addressed over 2 lakh viewers in several webinars, creating awareness about the various benefits and incentives available to them. Launched by the Government of India and on the importance of the wealth care along with health care. Dr. C. Abhishek Murali completed his schooling from TSPB schools, Chennai. Before he undertook his chartered accountancy course, he did his articleship training with PricewaterhouseCoopers in the Audit and Assurance Division. After qualifying as a chartered accountant, he went on to work with KPMG in transaction advisory, mergers and acquisitions on various national and international engagements. He has also completed his graduation and masters in commerce from Madras University. These are from ICI, these are from ICACA, USA, and SEMA from CIMA, London. Dr. C. Abhishek Murali has also completed his advanced diploma in international taxation with CIET London, and he has obtained his certification in international tax law and transfer pricing from Leiden University, Netherlands, International Tax Center, under the guidance of the world renowned Professor Kees Van Raad. He has also attended special session at Harvard University. He has also qualified the independent director data bank online proficiency test conducted by the Indian Institute of Corporate Affairs. Dr. C. Abhishek Murali is currently the partner of Measures Victor, Grace and Co. Chartered Accountants and lead the direct taxation appeals and litigations verticals. Dr. Abhishek is very passionate about startups and went on to establish a vertical to help mentor startups. He has been nominated as the honorary first secretary for the Honorable Consulate of the Republic of Zambia. Abhishek professionally advises various leading industries, high net worth industries and professionals. Dr. C. Abhishek Murali has been nominated to the Corporate Laws and Corporate Governance Committee, Professional Development Committee, Research Committee, which are constituted by the Institute of Chartered Accountants of India, New Delhi. He has been nominated as chairman of almost 11 committees constituted by SARC of ICI. In addition to the chairman for such committees, he is also nominated as a member for various committees constituted by SARC of ICI. Also, he has authored many books of professional interest. Also, he has authored for background material for investor awareness referencer published by the Institute of Chartered Accountants of India, New Delhi. Dr. Abhishek Murali regularly contributes articles on professional interest in the online magazine Tax Sutra. He has also addressed conferences, seminars, and workshops organized by various forums, professional bodies, universities, and income tax and central excise departments. Also, he has held many positions in various organizations. Due to time constraint, I have shortened his profile. If I go on detail, it will take some more hours. So we can understand that within the lesser age of 31 years, he has achieved so many positions in the profession. Sir, we congratulate you and wishing you all the best for the new heights ahead. With this brief introduction, I request today's speaker, CA Dr. Abhishek Murali, to start the technical section. Thank you, one and all.
Thank you, sir. I request CA Abhishek Murali, sir, to continue with the section.
Thank you so much, Arun. Very warm good morning to all the participants who have joined in today. Good morning to the chairman of Nellore branch, CA Vamsi Krishna, chairman of Ongole branch, Satyanarayana sir, and chairman of Tirupati branch, Sudarshanam Naidu sir. I must also thank all the management committee members who have been kind enough to join today's meeting, take time out of your Sunday and join this meeting. And special thanks once again to Sudarshanam Naidu sir, who gave a very, very kind introduction, very nicely has introduced me. So thank you so much. Sometimes I feel the way he introduced me, I don't deserve that sort of praise. So thank you so much, sir, for that lovely introduction. And of course, I thank all the participants also for taking time out of your Sunday schedule to join this program today. When Vamsi sir reached out to me on organizing this program, he was very specific. He said, we have to do on Vivad se Viswas. Somehow we will do early in the month itself, sir. And we'll try to coordinate a program so that our members have time to understand the form, etc. Now, we have the privilege of having our chief guest, Senthil Kumar sir, and of course, guest of honor, my council colleague, Chinnamastan, also with us. And Senthil Kumar sir gave a very, very lovely address. I thoroughly enjoyed what he did, and he touched upon in a very nice, brief manner on all the specific aspects of this entire act, this entire scheme, and also what role the department is playing. So I'm going to try and briefly touch upon some of the important basic aspects, the computation aspects, frequently asked questions, the common questions that all of us will have about the scheme and when we are trying to adopt the scheme. And most importantly, on the computation, when you are filling it up, what are certain challenges and how you have to fill that up. I'll be covering that as well. So I'm going to share my presentation now. Is my screen visible, sir? Okay, great. So as you're all aware and very correctly touched upon by all the previous speakers, this is a scheme introduced by the government for settlement. Now, this settlement scheme is not something new. We have had multiple schemes, almost 10 schemes have been done ever since India got independence. But the first thing that I want to point out is that many people, especially chartered accountants and even assessees, they say the tax is still little high, sir. If the tax was lower, if the rates was lower, then I would have adopted the scheme. Same thing for IDS also, they said, income disclosure scheme. After demonetization, when it happened, many questions came up saying, sir, the rate is a little high. 45 or 55% is little high, sir. I want a lower rate. Ladies and gentlemen, the first thing you must know is why you will never get a lower rate. You will never get a lower rate is because we have to go back to 1998. In 1998, the government had announced a Kar Vivad scheme where if you want to come under IDS, the income disclosure scheme, you can submit all your assets, all your undisclosed income, everything you bring into record, you pay 30% tax, everything is on record done. Now, this seems okay, it seems ideal. If we had a scheme like that today, 100% every assessee in India, they will come and they will be very honest, they will offer everything, they will pay the taxes, collection for revenue also will go up. But why? Then why are the government not doing this? I'll tell you why. I'll tell you why. Way back in 98 when this was announced, the case went up all the way to the Supreme Court. The reason was simple. If I'm an honest assessee, I'm an honest tax-paying assessee, I filed my return of income, I paid my self-assessment tax, advance tax, whatever. At the time of filing my return, my auditor says, sir, you have not paid advance tax properly. Interest is also there. I am saying, no problem, sir. With the interest, I will pay now. So with the interest, I have paid everything. I filed my return of income. I have complied with the provisions of the law. My neighbor, the person who lives next door to me, he has not filed his return. He is living in the same sort of wealth that I am living in. But he's saying, I don't have income at all. He is not disclosing anything. Finally, what happens? IDS comes up. So what does he do? He offers all his wealth, all his income in the 1998 IDS scheme. How much tax rate he is paying? 30% he is paying. How much tax rate I paid? 30% plus interest plus cess plus surcharge, everything I have paid. Whereas this person who is filing it late, he is a defaulter. I'm a person who's an honest taxpayer, but my neighbor who's a defaulter, a person who has not complied with the provisions of the law, he is getting a better rate of taxation than me. When I have been honest, I have paid interest. I will not get refund of my interest. But this gentleman, he is paying late. He is getting waiver of interest. He's getting waiver of penalty. He's getting waiver of prosecution. He's saying, bring all your assets, everything historically, what you have been not disclosing, you bring it. For me, year on year, I've been filing. Year on year, I'm paying interest. And I'm not getting any benefit. He is getting a benefit. So this case went all the way up to the Supreme Court, where the Supreme Court, they issued a whip against the government, where they said at the time, they said these schemes are good in nature, but at the same time, you are rewarding a person to be a defaulter. Therefore, in the process, honest taxpayers are being penalized. So ever since then, they took, in fact, an affidavit at the time. They took an undertaking from the government saying that no government henceforth in India will do a scheme where you will reward the defaulter and you will penalize an honest tax-paying assessee. That is precisely why, whether it is the Foreign Disclosure Asset, the black assets and the Black Income Act, be it the Income Disclosure Act that came after demonetization, or even the current Vivad Viswas Act, you are not going to find better rates. So please do not wait saying, I will wait for some time, better scheme will come. Every time one scheme lapses, the next scheme will not be as beneficial to the assessee. That is the first important point that we have to understand. The next important question, coming to the Vivad Viswas Act. One very common question that gets asked is, sir, is this an amnesty scheme? Let me clarify. We have to first understand the objectives of the scheme. As very rightly said by Senthil Kumar, sir, the fundamental objective is to reduce the litigation and to settle disputes before all appellate authorities. I think as Indians, and especially being certain experienced chartered accountants here, everyone is familiar with the legal system in India, and we all know how long it takes for a case to finish. When it comes to income tax, it is a little bit more friendly than that. It is not so bad. The income tax has a faster process. However, naturally speaking, because principle of justice, principle of law is involved, and many cases at some stage a lawyer gets involved, the case gets a little long drawn out. Many cases that I'm handling myself, assessment over, first appeal over, ITAT I'm handling the case, I'll fight out the case and I will get what is called a set-aside order. Set-aside means the ITAT directs the assessing officer to do a fresh assessment or to relook at the case. So they're saying I'm sending it back to the assessing officer. By the time it reaches ITAT itself, already 3 years over. Now, again, it is going back to the first level. One new officer will be there. The new officer also, he makes an addition. What will I do? I feel I have a strong case. Again, I will fight it on appeal. Ladies and gentlemen, you can imagine how long it will go. Even after the end of the next 3 years, even if ITAT gives an order in the favor of department, I will go on appeal again to High Court. So this, and you know, when it comes to High Court, how long it takes for a case to reach and for it to be heard. And this is the reality, ladies and gentlemen. Many cases that I'm handling even pertain to block assessment period. 97, 98 to 2002, 2003. Those cases are also still going on, And we are in almost 22 years later. 22 years later, the case is still going on. And I'm not even talking about high court level. I'm still talking about within the framework of income tax officer, assessing officer, CIT appeals, and the ITAT. So therefore, one of the paramount importance of this scheme is to reduce the litigation and to settle disputes at all levels. And of course, naturally, there is a lot of expenditure on the side of the department or even the assessee, because every case that I am filing at the ITAT, I will go and represent the assessee. He has to pay me for my appearance. Then the department also has to come and prepare. They will have a DR, or what is known as a department representative. He has to argue, like how you have seen in the court, in movies and all you would have seen in court. No, there will be one person arguing, other person from the other side will be arguing. The tribunal, the income tax appellate tribunal, is exactly like that. So you will have a person, a commissioner, or a person who's at least an assistant commissioner, DCIT, or even in some cases additional commissioner also will come and appear as a department representative at the ITAT level to argue cases. So significant outflow of time, money, and resources, both at the assessee level and the department level. In the entire timeline, I told you, 6 years, 7 years for each case. Can you imagine that? For each case, 6 to 7 years time it is taking to resolve the issue. So 6 years of time, money, and resources are spent on these cases. So the government wants to try to eliminate that and narrow it down to only the cases which are fundamentally required. And the third, naturally the important one, is to generate revenue for the income tax. See, end of the day, all your schemes have to generate revenue for the income tax, and it has to be done in a balanced way. Income tax can come and say, we will do settlement scheme, you pay 95% of your taxes. Then somebody will say, if I have to pay 95% of my tax, interest, everything, what is the point? I don't get any huge benefit. Maybe, but you have to take a balanced look at it. And in my view, this scheme is a very, very well balanced scheme. And the government are pushing heavily to make it a success. I think as auditors, we should also play a role. I'll explain why it is a very, very important scheme for that. Now, the first important question, who is eligible for the scheme? Who are the persons who are eligible for the scheme? Again, Sendil sir touched upon it. So I'll briefly, once again, explain certain important aspects. Where any appeal on any writ has been filed and pending before an appellate authority as on 31st January 2020 will be eligible for the scheme. Why 31st January 2020? The scheme was announced in the budget on 1st of February 2020 in order to give a cutoff date. 31st January 2020 was put. Now the next one is an important development. Initially, when it was announced, this was not covered, and then the government came out with a clarification. If you have any appeal that is pending as on 31st January 2020, that is, you have already filed it, then in that case eligible. But suppose there is a situation on 30th of January 2020, I have received the order from the assessing officer making additions. Now, how much time do I have to go on appeal to the CIT appeals? Under the Act, 30 days time, 30 days time from the date of receipt of the order I have to go on appeal to the CIT appeals. When have I received it? 30th of January. So how much time I have? I have till end of February. But at the same time, on 1st of February, the budget madam is announcing that 31st January cutoff date. So does that mean I don't have access to the scheme because my appeal is not pending? The government has clarified. Where the time for appeal has not expired as on 31/1/2020, you are also eligible for the scheme. If your time to file appeal, that 30 days time has not expired on 31st January 2020, then you have the time to still go on appeal. Now, next question. From when is this time reckoned? If I've got my order on 31st of December, 30 days. 30 days means 30th of January. So therefore, my time limit for appeal has expired on 31 Jan 2020. So how should I reckon this date? How you need to reckon is not the date of the order, but the date of receipt of the order. please remember, any appeal, if the scheme was not there, if I've received the order on 2nd January, even if it is dated 27th of December, you will not see it from 27th of December. You will see the 30 days from the date of the receipt of the order. So please check from the date you have received the order for the time limit for appeal when it has expired. Next question one more person will ask is that, sir, my time limit for appeal has not expired, okay? Or in another situation, I have filed an appeal to the Supreme Court, or I filed an appeal to the High Court. It's a writ petition of the High Court and Supreme Court. They do not straight away take up cases. They have something known as admitting of cases. Whether the case needs to be admitted and posted at all, that will be first examined. So can I ask you a question? Does the case have to be admitted, or is it enough if I just file it and show my documents? Sir, I filed it on 30th of January. See, that is all. Or do I have to have it admitted? Now, luckily, the act is very favorable to the assessor. Even a clarification that has come out on 4th of December, just a few days back, they have stated that if your appeal is filed and is pending, even for admission, even in those cases also you are eligible for the scheme. Even when it's pending for admission before the High Court or Supreme Court, then also you are eligible for the scheme. Sir, one more question. Sir, I have one more question. Sir, I have filed my appeal on 30th of January 2020. But actually, the time to file my appeal expired on 20th of January itself. So I have filed my appeal late before the CIT appeals or ITAT. But I've also filed condemnation of delay, sir. Am I eligible for the scheme? Because the hearing has not yet been taken up. So I don't know if it is eligible or not. Once again, 4th December 2020 CBDT circular has clarified where I have filed the appeal with the condemnation of delay before 31st of January 2020 itself. I am also eligible for the scheme. So even if you have filed with the condemnation of delay, even if your delay is 280 days, even if your delay is 20 days, even if your delay is 10 years, they are saying you will still be eligible for a scheme. Look at this highly beneficial provision. So if you have filed with the condemnation of delay before 31st of January 2020 and it is pending, naturally they are saying under the CBDT circular, you will also be eligible for the scheme. Sir, next question. Sir, I have received the order on 15th of January 2020. 15th of January 2020, I have received the order. My time limit to filing appeal before the CIT appeals, I have 30 days time. That has not expired on 31 January because 15th January only I have time till 14th of February. I have time till 14th of February to file my appeal. So therefore, my time to expire is not gone. I am still eligible for the scheme. But initially, the scheme was not announced. So I did not have any intention of going into the scheme. So what I told the assessee, I told him, sir, you pay the taxes, you pay the interest, it is fine. So assessee also said, I am not interested in appeal. I want peace of mind. I will pay full tax. I will pay full interest also, no problem. Now what has happened? We are in December 2020. The scheme seems beneficial. Assessee has paid a lot of interest. He has paid a lot of interest to 34 ABC. So assessee is now thinking, sir, auditor, sir, can I come under the scheme, sir? Can you advise me? Ladies and gentlemen, this is why it's a very, very interesting provision. The Act simply says that time limit for filing appeal has not expired on 31 January 2020. The Act nowhere says that the appeal should have been filed. So even if today in December you have not filed the appeal, but as on 31st January your appeal time was pending, you had time to file the appeal. You did not file the appeal. You did not have any intention of going on appeal or for the scheme. In December, you are evaluating and saying, oh, scheme is actually good. Why? When I have interest excessively I paid, I can take a refund of it. I can take a refund. Once the interest is waived, I will get the refund of the excess tax paid. So I will go under the scheme. Can you go under the scheme? Yes, you can still go under the scheme even if you have not filed the appeal, but the time limit for filing appeal has not expired on 31st January 2020. Even on December 2020, you can still apply and come under the scheme. Hugely beneficial provision. Please note that point. Please check for all of your assessees. If they have paid excessive interest under 234 ABC, you can file the case for the scheme and come under the scheme and get a refund also. Hugely beneficial. Cases pending before DRP as on 31/1. Revision under 264. Very interesting. There you're filing for a revision, or you're filed for a revision under section 264 on or before 31st of January 2020. You can also come under the scheme. You can also come under the scheme. Now the next question naturally you will ask me is, what about 263, sir? Revision under section 264 is an application made by the assessee seeking a revision. But 263 is a revision directed by the CIT, the Administrative Commissioner. He will direct the revision under section 263. What he will do, he'll pass an order saying that this order can be revised for this specific assessment year for this assessee. And he'll give a direction to the assessing officer to examine the information and pass an order making the additions. Now, the question was raised. 263 itself is not an assessment order. It is an order directing an assessment should be made. 263 is an order directing an assessment to be made. Can I challenge a 263 order? Yes, I can go on appeal against a 263 order itself. But I don't go to the CIT appeals. I challenge 263 directly to the Income Tax Appellate Tribunal. So where a 263 order is passed, let's assume in your assessee case, it's a partnership firm. One of the partners is Karta of HUF. What the department is coming and saying, HUF cannot be part of the firm. So 263 I am passing saying that any interest paid, any profit distributed, any salary paid, all that you have to disallow and treat it as if it is an association of persons because the partnership is invalid. Like that, a 263 order is passed. Now, two things I can do. One, once the order is passed, it goes to the assessing officer. I can fight out the case before the assessing officer, or I can challenge that 263 itself. I can say the revision itself is invalid because already all of what you are saying has been examined by the assessing officer. Like that, I can go to the ITAT and challenge. So therefore, for revision under 263, if I have filed an appeal to the ITAT and that appeal is pending as on 31st January 2020, what will happen? Ladies and gentlemen, if that appeal is pending as on 31st January 2020, then there is an interesting twist over here. You can come under the scheme. If it is pending on 31st January 2020 for the revision order, you can come under the scheme, but your 263 order passed by the commissioner must have been quantifiable in some sense. If your 263 order simply says, I think this assessee has not disclosed correctly, you please check everything and make the adequate additions. That is not a quantifiable order. It is a general 263 order. But if your 263 order says the assessee cannot take any partnership remuneration because he is a HUF, therefore any remuneration paid, any interest paid, you disallow that. That is a quantifiable 263 order. So where the order is quantifiable under section 263, then that also you can come under the scheme. But if it is general in nature, you cannot come under the scheme against the 263 order. The next point, this is also a very, very interesting point. And Sindhil sir, maybe he'll be aware of the discussions which have happened in the department. But you look at the Vivad se Viswas scheme, you look at the act itself, it says, if you are a taxpayer who has been subject to search under section 132 or 132A, where the demand, please note, not total income, not additions, where the demand is less than rupees 5 crore, then you are eligible to come under the scheme, even in such cases. Even such cases are eligible where the demand is less than rupees 5 crores. Now, next question you will ask, sir, every such case, they reopen 7 years, 6 years plus the current year. So 7 years will be touched in every such case. So that means, should I see all 7 years, whether it adds up to 5 crores to see eligibility or for each year? Ladies and gentlemen, department has been very, very kind. The government have been very large-hearted. They have said that where demand is less than rupees 5 crores for per assessment year, per year. So that 5 crore limit is not across your search. It is for each year that they are making addition. So if your demand is less than rupees 5 crore for each assessment year, you can definitely come under the scheme. Very good provision. Now the next point, the next very, very important question. Remember at the start of the presentation, I told you, I am still handling cases which pertain to 1998 and 2002, etc. Now let me ask you a question. Did provisions for such under section 132 and 132A exist back in 1998? It did not exist. Back in 98 and back in 2002, there was only what was known as block assessment concept. It was a block assessment. So when a search happens, they will take a block period. For 6 years will be considered to be one block. So they used to take a block period and continue the assessment. That was done under different sections. It was not done under 132, 138. It was done under 158 BFA, etc. So therefore, the next question you will ask is, who is eligible for the scheme? Sir, it says only people who are subject to search under section 132, 132A. Does that mean my assessee who is come under block assessment is not eligible for the scheme? So it's a big question that I had. Why? The department and government are serious about reducing the litigation, the first thing they have to target is the old litigation. The very, very old litigation, we have to eliminate that first. More recent litigation we can handle. But the old litigation, I need to get rid of. Old litigation means block assessment is very much part of this old litigation. So therefore, should that also not form part of the scheme? So the original reading of the act, and you take the act today also, that's what it says. But on 4th of December, CBDT circular, once again you go through the circular, there is a clarification issue. Will block assessment cases, such cases which are covered under block assessment, will I be eligible for the scheme? Yes. Even if you are subject to block assessment, you will come under the scheme as a search case. Why I'm segregating such case and a non-such case, you will appreciate in the next slides. So therefore, even if I'm subject to a such case under the old block assessment concept, I will also be eligible for the scheme as long as the demand for the entire block period. Now, this is the important distinction between block assessment and a regular search assessment under 132 and 132A is that in block concept, for your entire block, your demand should be less than rupees 5 crores. Whereas in the current provisions of the search cases, for each year, it should be less than 5 crores. But my view at that time, having demand more than 5 crores, unless you're a very high profile case, unlikely you would have had such a high demand. So you can still benefit by coming under the scheme. Next is the appeals and writs filed by the income tax department. Also, you can come under the scheme. I have won my case at the CIT appeals level. I have won it against the assessing officer. Department chooses to go on appeal to the ITAT. So therefore, case is pending at the ITAT on 31st January because department have filed the appeal. Then also I am eligible for the scheme. Then also I'm eligible for the scheme with certain beneficial conditions. So what are the benefits? End of the day, you will come under the scheme only if you get benefits. So let us ask the next important question. What are the benefits if I come under the scheme? The first and most important benefit, as very rightly said by Senthil Kumar sir, waiver of interest under the Act. Many cases, and we very rightly touched upon penny stock as an example, many cases where the interest alone under 234 ABC has exceeded the quantum or the tax payable. The tax payable portion is less than the interest. In fact, one case that I'm handling, which was referred by an auditor from actually Andhra region only, it was a Tirupati case in fact. The case referred by the auditor that I'm handling in this, the addition or rather the tax payable without interest is 47 lakhs. The tax payable after interest, or if I have to tell only the interest component alone, is 103 lakhs or 1.03 crores is only the interest component. That taxpayer is not been able to pay So litigation has been going on for so many years now. Suddenly scheme has come. If he takes the benefit of the scheme, he gets to save 1.03 crores. He is saying, sir, I've already paid more than that. I've paid 70 lakhs. But if you take only the tax portion, 47 lakhs alone I have to pay. I've paid more. What will happen? Now the scheme is saying you will get a refund, sir. Sir, we will give you back whatever excess you have paid. We will waive that 1.03 crores interest and we will give you back your excess tax paid. You are given thinking that you are paying for interest also. Today I am removing the interest. You will get back your excess money. Very, very beneficial provision. So waiver of interest is the most important part of this entire scheme. The next one, waiver of penalty. If penalty has been initiated against you, or if penalty has not been initiated, but they can initiate, time is still there. If you come under the scheme, penalty will not be initiated. They will not take care of any issues regarding your penalty also. The next point, non-pursuit of the case when it is settled through the scheme. The department, they will not say, sir, come for the scheme, we will settle. Once you settle, no. Next day they'll file an appeal. Sir, actually it is wrong what he has filed. You have to take up the appeal. That will not happen. The moment you get your final certificate under the scheme, the department also are giving you an undertaking. They're giving you a promise saying that they will not once again take up the case. They will not once again reopen. They will not rectify. They will not revise. The case is settled. That year will never be touched again by the department also. And of course, finally, prosecution also will not be pursued irrespective of the nature of the case if you come under the scheme. But there are certain exclusions. There are certain exclusions, as very rightly touched upon by Senthil Kumar sir. What are the exclusions from the scheme? Such cases which are greater than rupees 5 crore per year will not be eligible to the scheme. We all know that now. Prosecution cases where prosecution has already taken place. Normally, once the prosecution is done by the income tax department, it will be referred to their counsel, where it will go to your jurisdictional court or magistrate court and they will take action. In these cases where it has already been filed by the department, then in these cases you will not be part of the scheme. Cases relating to undisclosed foreign income, foreign assets, IPC, unlawful activities, PMLA, Benami transactions, coffee posa transactions, information on foreign assets or from foreign jurisdiction, all of these cases will not be part of the scheme. So if you are having issues or additions relating to all of this, you cannot come under the scheme. Therefore, the idea behind it is the scheme is meant for honest tax-paying assessees who are trying to go on appeal, who are trying to fight their case. For them, we will give it. Where I'm a fraudster, I'm a Benami person, I'm a person who's having assets from very, let's assume unethical practices, unethical moves, unlawful businesses that I've been doing, then the scheme is not for you. Even if you come under the scheme and subsequently it comes to light, let us assume there is an assessee. He is a person who's been fighting one case. He's pending an appeal. Then he comes under the scheme. He gets all the benefits of the scheme. He enjoys and he says, okay, done. Nobody can touch anything. Subsequently, it comes to light. It comes to light from certain information that actually he's a Benamidar. He's a Benamidar of Dawood Ibrahim. So all the assets he has been holding that he has now been able to come under the scheme. It has come to light that he is a Benamidar of Dawood Ibrahim, and those assets he has come under Vivad scheme and he has escaped the taxation. Then in these cases, the government has the right to revoke the scheme. They have the right to revoke the scheme, but only if you are engaged in unlawful activities. Where you were in the first place itself, you are not eligible for the scheme. If you come under the scheme by mistake or because you did not disclose correctly to the department, then they have the right to revoke the scheme. But in all other cases, they cannot revoke the scheme. Once the scheme is done, once they give you the certificate, you have got your immunity. The case is settled. The case is settled. It can never be reawoken. It is under sleep. It can never be brought up again. So therefore, the case is closed unless you are doing unlawful activities. Most important point, how do I calculate the tax? What is the tax payable? Look at the chart over here. This chart is going to be your Bible when it comes to what is your tax payable. When it comes to regular appeals filed by the assessee, the disputed tax, as long as you pay whatever is the disputed tax till 31/3/2021, that is enough. If I don't file by 31/3, okay, so one thing I have to bring up again, even though Senthil Kumar sir touched up on it, I have to highlight this. The date for you to file the form, you have to file the form by 31st of December. The 31st of December, you have to file the form. The government have notified for payment of the amount. For the payment of the amount, you have time till 31st of March. So filing of the form, filing of the Vivad se Viswas scheme has to be done by the assessee or the auditors by 31st of December. However, for payment of whatever amount needs to be paid, you have time till March. You have 3 more months time. Earlier, you did not have the benefit. They said cut-off date, you have to file and pay your taxes by then. Now they are saying you file by this date, we will give you additional 3 months, you pay your tax at the end of the 3 months. So therefore, the government have done a good move to benefit the assessee. Now here, how much should I pay? In what scenario, how much I should pay? Now we discussed various classifications earlier also. So where it is a regular appeal, that is, it is a non-search case and it has been filed by the assessee, then in that case, as long as I pay the disputed tax, it is enough. But suppose by 31st of March, whatever amount I have to pay, I am not able to pay, then I have to pay an additional 10%. Please remember these terms. I will explain what disputed tax, disputed interest, disputed penalty means. But this amount is important for you to know before we go to that. So disputed tax I have to pay by 31st of March. For whatever reason, I am not able to get the money. I do not get the loan. I'm having some difficulty. It becomes March ends, 31st March ends. Then I have to pay my entire disputed tax plus an additional 10%. Similarly, where it is a such case and the demand is less than rupees 5 crore per year, then by 31st of March 2021, I need to pay my disputed tax plus 25%. This is in a normal search case. Normal search case, by 31st of March 2021, I need to pay whatever disputed tax plus 25%. Suppose in the same search case, 31st March, I'm not able to get my money, I'm not able to pay. If I'm making the payment after 31st March, then I have to pay disputed tax plus 35%. That is 10% additional charge they are charging me if I am delaying. What about if it's a department appeal? I won the case at CIT appeals. Department has gone on appeal to ITAT. Here I have the case in my favor, but department has gone on appeal. Here also, should I pay the entire amount? No, my friends. Here they have said where the department has gone on appeal, then it is enough if you pay 50% of the disputed tax as on 31st March 2021. After 31st March 2021, I am not able to get the resources. 55% you have to pay. So if it's a department appeal, only half the disputed tax you can pay. Now, some of you might say, sir, why I should pay half the tax? I have a strong case. I won it at CIT appeals. No. So you should give me more beneficial. The scheme is saying the best benefit will give you is half the tax you can pay. If you still feel that you have a strong case, then you argue the case at the ITAT level. You argue it. You don't come under the scheme. You please argue the case. But if you want the benefits of the scheme, you are not sure. I won the case at CIT appeals level somehow, but ITAT level, I am not sure. Or maybe department has got suddenly more information. Maybe another case has come up, similar facts of yours that has gone against the assessee. All these have come out after you have got the CIT appeals order. But department have filed appeal at ITAT. Your case has not been heard. Then please come under the scheme. You pay half the tax. That is enough. Next question. When it comes to disputed interest, penalty, or disputed fee. Now, let's assume there is a situation where assessment is taken up, additions is made, you have fought it out all the way to ITAT level, and you have lost the case completely by then. So you have not gone to High Court. Assessee also said, no need to go High Court, sir. We'll just pay the entire quantum, whatever we need to pay. You have paid the entire quantum. Suddenly now, department, they are raising penalty also. So they have passed a penalty order, 271(1)(c), they have passed. So now what you are doing? You said, sir, Quantum, okay. Quantum, I would have been, I'm okay to pay the tax. But how can they raise penalty, sir? It is highly incorrect. You please file the appeal. So you have filed the appeal and your appeal against the penalty is alone pending. Then that also you can come under the scheme. That also you can come under the scheme. So where there is any case that is pending at the appeal level that relates to either disputed interest, and here disputed interest is any interest other than interest under 234 ABCD. So any interest other than 234 ABCD, if there is any other interest, let's say interest levied by TRO or 234F, 34E, these are also disputed fees. Any disputed fees, disputed interest, or disputed penalty which is pending an appeal, that also you can come under the scheme. So where your dispute relates to either disputed interest, penalty, or fee, and the appeal is filed by the assessee, then you have to pay only 25% of that disputed amount. I am on appeal against a penalty. They are demanding 1 lakh from me. Then if I pay 25% of that 1 lakh enough, 25,000 rupees alone, if I pay, it is enough. I don't have to pay any more. It's hugely beneficial scheme, especially if you are under disputed penalty or a disputed interest. Suppose by 31st of March, I don't have time, then you have to pay something additional. They are saying you pay 30%. If you're paying after 31st March, then you pay 30%. Before March means 25%. Now same penalty case has been levied by the assessing officer. I've gone on appeal to the CIT appeals. CIT appeals has given in my favor. Assessing officer decides to file the appeal to ITAT against the CIT appeals order. So therefore, appeal filed by department pending on appeal. In this case, I have to pay half the amount. So if I pay 12.5% of the disputed penalty or interest or fee, it is enough. Similarly, if I'm not able to get the money by 31st of March 2021, then after that, if I'm paying, in case the appeal is filed by the department, I have to pay 15% of the disputed sum. So this is the details of the amounts payable under this scheme, the details of the amounts payable under this scheme. Now let us come to the important part. Key terms. We have learned disputed tax, disputed interest, disputed penalty, and disputed fee. These are very, very important terms that we need to understand. The first thing, if you look at the act, it uses the term tax arrears. The tax arrears, whenever there is tax arrears for the assessee. So what does tax arrears mean? If you take the act, it will say tax arrears. Tax arrears means it is the aggregate of disputed tax, disputed penalty, and disputed interest chargeable on this together is known as the aggregate of the tax arrears. So therefore, first, let us understand what is disputed tax. Disputed tax refers to income tax, including surcharge and cess. It does not include your 34 ABC. So disputed tax means income tax, surcharge, educational cess, secondary educational cess, whatever is applicable. There is no such thing as 234 ABC in your disputed tax. This is very important. When you are filling the form, this term is very, very important. Now, there are certain different scenarios. Now, where an appeal is pending, what amount I should say? The amount payable in case that appeal was decided against me, then that amount has to be included. So therefore, if there is a situation where there is an enhancement or a notice of enhancement by CIT appeals, you will all know CIT appeals has a unique power. This power is there only with the CIT appeals, where they have the power of enhancement of your assessment order. Assessment order has been passed against me. They have made additions saying that your salary income is so much, your interest from other sources, your income from other sources of your savings bank interest, you have not disclosed. I am making an addition. Your CIT appeals, when he is going through this, he finds that there is a fixed deposit interest also that you have not offered. So what he is saying, I am making an enhancement. Assessment order made addition of 100 rupees. I am making an additional addition. So enhancement of your assessment order by 200 rupees for the interest on fixed deposit that you have not disclosed also. Only the CIT appeals has the power to do this. Even your ITAT, High Court, Supreme Court do not have the power for this. Only CIT appeals. So let us assume in one case, they have issued a notice to you saying, I'm going to make an enhancement. but order is not yet passed. Then in that case, if you want to come under the scheme, you have to include the enhancement also in your disputed tax. So you have to pay wherever they want to enhance or they've issued a notice for enhancement. Even if the order is not passed by the CIT appeals, that amount will also form part of your disputed tax. Where order is passed, but time for appeal has not expired, then naturally that time tax payable as per the order that you would have gone on appeal will be the disputed tax. Where application for revision under 264 is pending, whatever disputed tax along with any enhancement if required in that case will be your disputed tax. Now, this is just a summary table of whatever we have discussed. I've put it on the screen. I'll be happy to share the PPT with you so you can go through this at your own leisure. The next one is disputed interest. As I already told you, when I say disputed interest, I am not talking about 234 ABC. Please remember, 234 ABC does not form part of this interest. This is interest in any other form, maybe tax recovery officer, interest levied by other authorities. All of this will be forming part of your disputed interest. It does not include your 234 ABC. So I can file an appeal or I can file under the scheme where any other interest is also levied on me that I am fighting out at some stage. Disputed penalty. Let us assume there is a disputed penalty which has been raised on me. Then naturally the amount of the penalty without the income tax, without the cess, etc. It's only the penalty amount as per the penalty order. That will be the disputed amount when it comes to disputed penalty. Now the most important thing. Procedure. How do I, if I want to come under scheme, what is the procedure? How I should come under the scheme? The first thing you need to do is file a declaration under Form 1 and Form 2. This entire process is online. Now, if you log in for any assessee, you log into the income tax portal, there'll be one tab in the top right corner known as Vivad Se Viswas. You have to click that tab and click submit your documents. So therefore, you want to file a scheme. So you file a declaration under Form 1 and Form 2. Once you file this form, the department will grant you a certificate under Form 3. They will say, this is the amount payable. Suppose I am saying disputed tax so much, disputed penalty so much, disputed interest so much I have to pay. I have to pay X amount of tax. Department can come back and say, no, X is incorrect. Why you have to pay? So you have to sit and reconcile with the department, come to what is a mutually agreed figure, and you have to revise to the form. Once the figure is agreed, you all agree, yes, X amount only is payable. Then department will give you a certificate in Form 3 saying this is the amount payable. You have to pay the amount. Now, earlier, what the scheme said, once the department gives you that certificate, within 15 days, you have to make the payment. Now, what they have said, up to 31st March, you have time. Up to 31st March 2021, you have the time to make the payment. So therefore, the amount that is determined by the assessing officer, you have to make the payment for that. The next step, withdrawal of appeal before the CIT appeals, ITAT and payment. If I come under the scheme and I don't withdraw the appeal, then later on I will go on appeal and I will fight. Sir, I came under the scheme, but actually I want to fight on appeal also. Then the purpose of the scheme is lost. The moment you come under the scheme, it is the duty of either the department or the assessing officer to withdraw their appeal from the scheme. They cannot keep the appeal pending. So the moment my amount is accepted and Form 3 is given by the department saying, yes, we are accepting whatever amount you have said, we both will agree that so much is the amount that you need to pay, then it is my duty to withdraw the appeal wherever the appeal is pending, and then I have to pay the tax and furnish what is known as Form 4. Along with my tax payment challan details, I have to furnish a Form 4 to the department and I will submit the Form 4. Once the Form 4 is submitted, the department will scrutinize whether you have withdrawn, they'll check whether you have paid the taxes, and they will give you a certificate, an acknowledgement in Form 5. This Form 5 is the finality of the scheme. That is the certificate that you have come under the scheme and you will enjoy all the benefits of the scheme over here. So that is the overall scheme structure. And to show you, now I'll show you certain screenshots as to what it looks like. Some of you may have already filled the form, therefore you will be familiar with it. But this is what the form looks like for you. When you log into the income tax portal and you select Vivad se Viswas scheme and you want to fill, you'll have to select the assessment year. You'll have to select yes or no, whether it is a TDS or TCS case, select that and accordingly submit the form. So once you submit, you will have part A, which will have the normal details, PAN, TAN of the assessee, Aadhaar number, first name of appellant, all of this will automatically, it will pre-fill. The one thing you have to select, you have to give a declaration whether the appellant in terms of section 2 of the act is not ineligible. We discussed to know who and all is ineligible. So as long as you are not in that, you can simply select yes, the assessee is not ineligible, he is very much eligible. So you have to select yes over there. The next option, as Senthil Kumar sir very rightly said, you have another option. You have an option. Suppose I'm a loss paying assessee, I'm a loss making assessee. There's been an addition in my case. They have made an addition saying my loss I have said is 10 lakhs. They have made an addition of, let's assume, 2 lakh rupees. So here, what is the tax payable? The tax payable is still nil. But suppose I want that benefit of that carry forward of that 2 lakhs loss. If I want the MAT credit relating to that year, then also I can come under the scheme. So if that appeal is pending, what will I do? You will ask, no, sir, loss only. How do I know what tax to pay? So since the addition made is 2 lakhs, whatever notional income tax was payable on that 2 lakh rupees, you have to pay that amount. Only then will you have the benefit of that additional 2 lakhs carry forward of loss and MAT credit. So if I'm an assessee who's adopting for this part of the scheme, then I can select yes over here. I'm a loss making assessee. I want to adopt this notional payment of tax, and you have to select that and you have to fill what is known as a Schedule D. Schedule D. The other schedules will not be as applicable to you. So you have to go straight away to Schedule D. But 95% of the cases will be in the other conditions only. So you have to fill up what is known as Part B. What you saw the previous page was Part A. What you are seeing on the screen now is known as Part B. So when it comes to Part B, how will you determine the amounts that what needs to be filled? So this is what you need to fill. Nature of the tax arrear. Is it disputed tax? Is it disputed penalty? Is it disputed interest or disputed fee? We already saw those terms. You have to select the nature of the tax arrears. Then what section the assessment order was passed, read with what section. For example, passed under section 143.3, read with section 147. That you have to fill out over here. Next is whether the appeal is pending before any income tax appellate authority or which appellate authority has passed such order. I request,
sir, can you mute?
Yeah, I request all participants, please mute your audio. Okay, thank you. So you have to tell which appellate authority has passed the order. Suppose I'm going on appeal to the ITAT, then that means CIT appeal has passed the order. If I'm going on appeal to CIT appeals, it is pending there, then who has passed the order? The assessing officer has passed the order. So that I have to select. It's all matter of facts only you're bringing out over here. But what is interesting is once you start filling it, you will understand. It's very straightforward. What is the reference number, whether you have filed an appeal or whether it is a writ appeal or mediation conciliation, you have to fill out which appellate forum it is pending at, whether you have already filed or do you have time to file, all those details. If you have filed, what the date you are filing, all those details you have to fill it out. Very straightforward. The only complexity comes over here is, let us take a scenario where your assessee has got an order under section 143.3. You've gone on appeal against that. CIT appeals dismissed your appeal. You have gone to ITAT. So your case is pending against the order passed under section 143.3 for, let's assume, assessment year 9-10. It is pending before the ITAT. Meanwhile, when all of this is happening, the assessing officer has passed an order under section 147 also. He has done a reopening assessment also for the same assessment year on different issues. Now that order is passed, you have gone on appeal. That is also pending before CIT appeals. Now let me ask you a question. If I'm coming under the scheme in this scenario where 143.3 is passed, appeal pending against ITAT. 147 also passed for the same assessment year on different issues, which is pending before the CIT appeals. Can I come under the scheme? It appears based on what we have discussed that yes, I can come under the scheme. Now, next question. If I come under the scheme, does that mean I have to come under both parts of the scheme? That I have to come for both the assessees, I mean, both the appeals that is pending at ITAT, that is pending at CIT appeals also, or can I cherry pick saying, no, sir, I will come under the scheme only for 143.3 order. I don't want to come under 147. I will fight to the 147. Or is the department saying you have to come under both? Now, here's where it's interesting. Each appeal is distinct in nature. Each appeal is distinct in nature. So therefore, I can determine which appeal I want to go under the scheme. So therefore, I can say I will go only against the 143.3 order. I will not go against the 147 order. So therefore, only the 143 order I have to fill, but I have to mention if any other appeal is pending. I have to mention one appeal is pending for the same assessment year against the CIT appeals. I do not have to bring out the figures or anything. I just have to mention it is pending. So therefore, that is a very important appeal. Now the next question, let me ask you one very practical case that I handled. One case which was referred to me. The auditor had appeared before the assessing officer, and what happened is 9 hearings took place. It was a penny stock issue, just like Senthil Kumar sir said, penny stock issue. After 9 hearings, that auditor told the assessee, see ma, worst case scenario, they will disallow the exemption given under section 1038 for you, long-term capital gains on sale of equity shares. They will disallow that section 1038 allowance for you. Are you ready to pay? Assessee said, yes, sir, I am ready to pay. It is a mistake on my part only. I will pay whatever amount. Finally, order is passed. In assessment order, 2 additions are there. First addition, disallowance under section 1038. No problem. Second addition, what they have done, they have made saying addition or because of movement in capital. They have made a huge amount of addition saying movement in capital, unexplained movement in capital. Assessee and auditor both are saying, sir, 9 hearings we had, sir, nowhere they asked. They did not issue any show cause notice. Nowhere they have asked saying that we have to explain the movement in capital. Suddenly order they are passing, they have made the second addition, sir, no discussion had. Now the question that you would have asked. I want to come under the Vivad scheme. Why? The interest alone is extremely high in this case. It relates to assessment year 1230. So interest for 6 years itself has become twice the amount of the tax payable. So therefore, assessee stands to benefit. But at the same time, the tax payables includes a movement in capital, which I can explain. FD has matured during the year. My father has passed away, so all of his assets I have inherited. So that is why my capital has moved. I can explain the movement in capital, but I have not been given an opportunity. Now let me ask you a question. In this scenario, can I choose what issue I want to go on appeal? Sir, only the first one I will settle in the scheme. The second addition, I will not settle in the scheme. That one, I will fight it out on appeal. Can I have the opportunity to do that? Ladies and gentlemen, this is where you need the clarity. I cannot cherry pick issues. The moment I'm going under the scheme against an assessment order, that means all the additions in that assessment order, I have to agree with and I have to fight that out under the scheme. Or I have to choose, no, I don't want the scheme. I'd rather fight out the case. So the assessee has to take a conscious decision as to which is more beneficial for him. Whether I'd rather fight out the case, both the penny stocks and the movement in capital, or I prefer to go under the scheme. Only the penny stocks case and the movement in capital, both I will go under. I cannot choose. Only one I will do appeal, the other I will do under the scheme. You cannot do that. So you have to take a call, which one is more beneficial, either appeal or the scheme. So that is a very important thing. Next exam, next question. Sir, same year, assessment order passed, addition made. I'm on appeal against that addition. That is pending at the CIT appeals. At the same time, penalty also passed. Penalty order also passed by the assessing officer. That also I'm on appeal against the penalty order. That is also pending before the CIT appeals. Now scheme has come up. I'm going to take the opportunity of coming under the scheme. So let me ask you over here. How many Vivad se Viswas applications do I have to file? The answer is 1. What they are saying is, as long as it is the same assessment year, how many ever issues that you have to bring it out all in the same form. So what you are seeing here, first line item, you will select disputed tax. Next line item, I have to select disputed penalty. So here you will have a button called add. It is not visible in the screen, but you'll have a button called add over there. You press that add button, you can add how many ever line items you want. Disputed penalty, I can add. Disputed interest, I can add. Again, disputed tax, I can add. That could be a different order, like how we discussed one example, no? 143.3, 147. Suppose both I want to come under the scheme. Then that also I can put over here by selecting nature of tax arrears, disputed tax, different sections, different orders, but for the same assessment here. So everything has to feature in a single form. It's a very, very important point. The rest of this part B is very straightforward. Your reference number, date of filing of appeal, who it is pending against, when you have filed the appeal, all of those details you have to fill out over here. The next is known as Part C. Now this Part C is a mostly auto-populated section. Your tax arrears here will fill from your schedules. Your total amount payable under the scheme will fill from the schedules. Only your Part E, whether the declarant has made any payment of the tax arrears before filing the declaration. Now I'll give you an example. Assessment order passed, addition made. Tax payable including interest is rupees 1 lakh. So let us assume the quantum or the amount payable without the interest is 70,000. Interest under 234 ABC is 30,000. So 1 lakh rupees payable. Now, the assessee at the time of filing return of income, he has already paid 30,000. So therefore, balance 70,000 left. Now under the scheme, I'm coming how much tax I have to pay. Totally 1 lakh tax payable. 30,000 is the amount of interest. So only 70,000 I have to pay under the scheme now. How much has the assessee already paid? 30,000. 30,000 he has already paid at the time of filing return of income itself, he has paid. So therefore, balance 40,000 only payable. So here, the disputed tax is only 40,000. It is not 70,000 because department has also accepted you have paid 30,000. As an assessee, I have also accepted I have paid 30,000. So the disputed tax in this scenario is only 40,000. Now for this 40,000, what department have done? They have attached your bank account. They have seized the money from that. Then you have made some payment. All that payment and all will get adjusted against that 70,000. Now those payments, whatever payments you have made after the assessment order is passed, please note, all payments made after the assessment order has been passed, that the department has not accepted or they are not aware of, or it has not brought out in their computation. Whenever they pass your assessment order, there will be one demand computation that they will attach and they will give it to you. Whatever payments you have made that does not feature over there, please bring this out over here in this Part E. Look at Part E, point number 1. Whether declarant has made any payment against tax arrears before filing declaration, select yes. In this drop down box, you select yes, and you have to fill out the BSR code, date of payment, serial challan number, and the amount payable. And then the adjusted amount only you have to pay as a tax payment or net refund you have to collect. Now here is one very, very important point that there is still no clarity. And I'm not sure if Senthil sir is still here with us, but maybe as a department representative, he can give us some clarity. See, fortunately or unfortunately, we have now the form 26AS. Now 26AS will bring out any payment of taxes made. Now, if the tax has been adjusted by the department, assuming I'm on appeal against that case, after March 2020, department has suddenly during lockdown period, they have frozen your bank account, they have attached money. Trust me, this has happened in many cases. I am not giving you imaginary scenario, very real scenario. Many of the cases, almost 160 Vivad Viswas schemes we are filing. I am telling you, at least in 25% of the cases minimum, I have seen personally where the department, even after March, they have attached money from the bank account of certain assessees. So now the question arises, where, how will I get the details of the tax which has been paid or attached by the department? I am not aware, no, I have not received any communication. Current year refund, they have adjusted against this demand. I don't know how much has been adjusted. How do I check this? please take the 26 years before you file your assessee under the scheme. Take out that year latest 26 years, you take it out and you see all the tax paid. You will be having no below details of tax paid. Go through the details of tax paid. So any adjustment made by the department will also come out over there. So ensure all the figures are correct. The department details, whatever they've adjusted, all of that is also brought up. Now my big question is over here, and it will be great if Senthil sir can give us some clarity, is because your 26 years, till what year you can take out your 26 years? The last year that the 26 years, the oldest year the 26 years is available for is assessment year 2008-9. So if you are on appeal for any case that pertains to a year before assessment year 2008-9, there is no 26 years. So this is the question that I have. Where my appeal is before assessment year 2008-9 and I have made various payments after the assessment order has been passed. Department also agrees I have made the payment. But when I fill out the payment here, I don't have details of BSR code. I don't have challan number. All those details I don't have. But I have details of the payment. It has gone from my bank statement. It has been adjusted by the department. How do I fill this column? Some detail that I'm filling is incorrect. Either BSR code I'm making up, or challan number I'm making up, or date I'm making out. Amount alone is correct. But something, one of these figures, I will not be able to fill. So here is where there is a lack of clarity. And in fact, in some of the block assessment cases that we are handling, we went into the department, we sat with the inspector, we sat with the assessing officer, we sought for information. Even department also don't have BSR code, they don't have challan number, they don't have. But amount alone, we know, both of us know so much amount we have paid, but we don't have details of what is the BSR code, etc. So how we are going to tackle these cases? The department have very clearly said, the CBDT have said, block assessment also eligible for the scheme. But how am I supposed to fill out these columns is something I really don't know. And I think we need some clarity. I hope the department will come out with a clarification saying, if there is no BSR code details available, either with you or the department, you can fill any number. We will take it up and just reconcile if really you have paid the tax or not. So therefore, we will not say BSR code is wrong, so we are rejecting the scheme. So that will be highly unfair and unfortunate because that BSR code details is not available before anybody. So this has to be taken care of by the department. If you ask me how I should fill, honestly, I also don't have an answer. Better you wait till the last week to see if any clarity comes on this matter. So if your assessment pertains to any year after assessment year 2008-9, take out the 26 years and please fill out very carefully and ensure your assessee gets the full credit of all taxes paid, refunds adjusted, and bank accounts seized by the department. Now, next you have to fill out what is known as a Schedule A. What you see on the screen is the Schedule A. It's also a very simple form, but certain doubts people may have over here. So I will explain to you what you have to fill under each row. The first thing is the appeal reference number or your acknowledgement number. Whatever you filled in the previous page, the same thing has to be filled over here as an appeal reference number or acknowledgement number. The next thing, total income as per the order. This is very simple and straightforward. Whatever additions, total income including additions will be filled out over here as a total income as per the order against which appeal has been filed. The next one is your disputed income out of A, where your disputed income relates to issues which have been decided in favor of the assessee and for any assessment year before any of the appellate authorities. Let us assume, we'll take a scenario where addition has been made in my case regarding one particular issue, maybe provision for warranty or something like that. Addition has been made against my case. Very same provision for warranty issue. Last 3-4 years it has been going on for me. Every year it's been given in my favor. This year also I am on appeal. Now the question which you can ask, I want to come under the scheme. I want to come under the scheme. How much I should pay? They are saying where there is any issue which has been decided in favor of the assessee, if you want to come under the scheme on that issue, then you pay 50% of the amount paid, it's enough. So in the assessee's own case, the same issue, any appellate authority has given a decision in your favor, then you want to come under the scheme, then you have to pay 50% of the tax, enough. But one thing that I think all of us will agree, if any appellate authority has given the decision in your favor, Nobody will come under the scheme. I'll prefer to go on appeal. I will say in my own case, I've got a favorable decision. I don't want scheme and all. You please give me favorable order. Most likely you'll get the order in your favor also. But for whatever reason, suppose you want to come under the scheme, then you pay 50% enough is what the department is saying. Next, where issues, the disputed income relates to issues other than what is there under B1, then that will have to be filled out over here. So where no favorable order is there under any appellate authority for the same assessee, other issues will be filled out in B2. 95% of the cases, you will be filling only B2. So B1, you put a 0. B2, you fill out whatever is the disputed income. Disputed income means whatever additions they are making, that is your disputed income. Then C, disputed tax in relation to B1. Assuming it is 0, you put 0. Disputed tax in relating to disputed income at B2. Here, disputed tax is a very, very important term. It does not include the interest. It does not include your interest under 234 ABC. So disputed tax means whatever tax I have accepted in my return of income. While filing my return of income, tax payable is 30,000. I have accepted, department also accepted. Addition made, 70,000 is now determined the tax payable. So therefore, the disputed tax here is 40,000. It is not 70,000 because 30,000, even I am not disputing, department is also not disputing. Only the addition of 40,000, the tax which has come because of the addition of 40,000 is the disputed tax. So disputed tax excluding interest under 234 ABC, you have to put that over here in line item number D. Then E, tax effect of enhancement if any. Suppose CIT appeal is making enhancement, then that amount you have to put over here. Total disputed tax auto calculated section, that is number 5, line item number F is auto calculated. Now line item number G, this is where I'm getting the most doubt from many chartered accountants. People who are calling me have a lot of doubts in this line item number G. Interest charged on the disputed tax. Now many people asked, is this disputed interest that you are saying other than 234 ABC? It is not, sir. Here G means the interest leviable under 234 ABC only. Now the next question they asked, sir, you said 234 ABC waived, no? That means the entire 234 ABC will be waived. Yes, sir, but please wait. Please wait. Interest charge on disputed tax means, let's assume I have filed my return of income. I have paid a tax of 30,000. Same example, 30,000 I have paid at the time of filing my return of income itself. This 30,000 I have filed also includes interest under section 234 ABC. I have filed a belated return at the time of filing my return of income. So I have filed along with interest under 234 ABC levy. Now let me ask you a question. I have now have an addition and more taxes payable. More interest is also payable. When I'm getting a waiver of interest, is that waiver of interest only on the additional interest which has come now, or is it on the total interest under 234 ABC? Now, here is where many people have doubts. Please let me clarify. Look at the wording under line item G. Look at the wording under line item G. Interest charge on disputed tax. The original 30,000 that I paid at the time of filing my return of income, is it disputed? It is not disputed. It is undisputed by all parties. It is undisputed. So therefore, the disputed tax is only 40,000. That is total tax 70,000, 30,000 paid at the time of return filing, 40,000 now because additions have made has come out. So therefore, what is the disputed tax is only 40,000. So only the interest charged on that 40,000 will be waived for me. The interest when I filed my return of income late, originally I filed my interest of return of income late. So therefore 234 ABC levied, that will not be waived, my friends. That will still be payable. That will still be payable. Only the additional interest because of your additions, only that will be waived. Please note that it's a very, very important thing. Penalty levied on disputed tax. If there's any penalty levied, you can bring that out over here. Tax arrears will auto calculate, and then finally amount payable under the scheme. See how the calculation is over here. If it is a non-search case, 0.5 into C. 0.5. What is C item? C item is disputed tax where any appellate authority in assessee's own case on the same issue has given in favor. Then 50% of that amount, if you pay, it is enough. Very good. But assuming 95% of cases, this situation will not be there. So again, come 0.5C plus D. What is D? Disputed tax in relation to disputed income. That is your additional tax payable, excluding your interest. That will come under this D item. So that is the tax payable. E, tax effect of enhancement, if any. So CIT appeals is going to make enhancement, tax effect of that you have to add. That alone will be filled under your amount payable under the scheme, if it is a non-such case. If it is a such case, you add that additional 25%, add additional 25% in all of those cases. So that is if it is a such case. So you have to fill this out manually, you have to calculate and you have to fill it out. If you put a wrong figure over here, then department will come back and say error is there. So this you have to fill out. Whatever you fill over here, whatever you fill in schedule A, whatever you fill in schedule A, it will get auto populated here in this previous schedule, part C. Remember, we saw this page. This page, it will get auto populated from whatever you fill in schedule A. So therefore, tax arrears will fill from here, amount payable under scheme, amount payable in case you delay beyond 31st March will auto populate. Everything will come here based on what you fill in schedule A. So now you'll be asking, what is schedule B, what is schedule C? Same, exact same thing. Whatever we saw in schedule A, exact same thing will be there in schedule B, except schedule B is for TDS TCS cases. So where you're on appeal in case of TDS TCS for related filing cases, that you have to fill up there. What is schedule C? Schedule C is for disputed interest, disputed penalty. Whatever we saw schedule A now, that is for disputed tax only. It is not for disputed interest, disputed penalty, disputed fee. Where you have any disputed interest, disputed penalty, disputed fee, you have to fill schedule C for that. How schedule C will be? Exactly same as what we saw over here. Instead of saying disputed tax, there it will say disputed penalty or disputed interest. That is the only difference. Otherwise, like for like, you'll be filling whatever you are filling. Now you will ask, what is schedule D? What is schedule D? Ladies and gentlemen, schedule D is where I told you, suppose I'm a loss-making assessee, addition has been made, but I'm continuing to be loss. I want loss for carry forward. I want loss for MAT credit. Then in that case, I will have to fill out schedule D. It is a very straightforward schedule, but you have to fill that out separately in case you're a loss-making unit where you want to pay the tax on the notional loss or notional tax on the addition because of the loss. You want to claim the loss. Then you have a verification. Verification tab is very simple. It will be auto-populated. You have to just fill your Aadhaar number, date, and wherever location you are filing, and you have to fill that out. Similarly, form 2. Form 2 is also auto-populated form. You just have to fill out Aadhaar number and place. And after that, you have to click submit. Once you click submit, you will get an acknowledgement saying form submitted. The form will go to the department. Department will do their own scrutiny. So my advice over here is, the moment you submit the form, if you have time, go and meet whoever is your designated assessing officer or whoever is the designated authority for your case in your jurisdiction, and ensure that you both come to the same page and the figures are both agreed upon. Once you agree upon the figures, they will pass what is known as the Form 3, giving you the certificate of the tax payable. Some key points to note. I've already told you where you have paid excess amount. Suppose assessee has to pay totally 1 lakh he has to pay. That is 70,000 tax, 30,000 interest under 234 ABC. Appeal is pending. He now comes under the scheme. Then what is the tax payable? 70,000. But assessee has already paid 1 lakh. He has already paid 100% of the tax plus interest. What happens to the extra 30,000 he has paid? The department have clarified whatever extra you have paid, that is including the interest amount, that will be refunded. It will be returned to the assessee. Don't worry about it. I've already told you multiple grounds what you should do. When there's a reduction of loss also we have covered. And of course, more importantly, filing declaration does not set a precedent. Assuming I'm going on appeal for assessment year 9-10, the issue pertains to penny stocks. Penny stock issue, I'm going on appeal and I'm coming under the scheme for that case. Scheme has come, department has passed the final form. I have got the benefit of the scheme. I've got the immunity. Now next year, assessment year 10-11, same penny stock issue. Can I say in appeal or in the course of assessment, already I have given Vivad se Viswas scheme, you cannot raise the issue. Please note, this is not an amnesty scheme. It is not an amnesty scheme. It is only a settlement scheme. So both you and department, both of you are only agreeing saying that, sir, I will not come under the scheme. I'm not interested under the scheme. Nobody is saying that it is a precedent. So neither the department also can say it is a precedent. You have accepted and you have paid tax. That means every year you have to pay tax. Assessee also cannot say you have accepted that it is nothing. So therefore I should not pay tax in later years. It pertains only to that assessment year, only to those issues in that particular year. It does not set any precedent for either party in the futures. Now, frequently asked questions. So many of this I have covered in the course of my presentation, but I will just quickly touch upon. What if appeal is pending but order is passed? I've already told you, if it is pending, you have time limit, then you can still come under the scheme. If I filed a miscellaneous application is a power before the ITAT, where suppose ITAT passes an order and there is a mistake apparent in that order, that by mistake they have said everything they have agreed with my arguments, but in the final line when they are writing, they are saying appeal dismissed instead of saying appeal accepted. So what will I do? I cannot go to High Court on this. It is ever apparent on record. ITAT itself has the power to rectify this error under what is known as section 254 subsection 2. So I file a miscellaneous appeal saying that there's an error apparent on record. Now question was asked, whether this error apparent on record, if you have filed, are you eligible for the scheme? Answer is, if you have filed it before 31/1/2020 and it is pending, even if it is not restored, then also you are eligible. Whether it is restored or not, if the appeal is pending, you are eligible to come under the scheme. Most of this I have already covered. One important thing, what if the appeal is set aside by the ITAT? I have gone to ITAT. ITAT has set aside the case, saying give the assessee a proper opportunity to be heard. Now here is a big question mark. Is the appeal pending? Is any appeal pending? Where they have sent it back to the assessing officer, it has come back to the assessment stage. So only assessment is pending. Appeal is not pending. So can I come under the scheme? Big question mark. Only if your appeal is pending, can you come under the scheme? Vivad se Viswas, that is, you are getting relief from fighting. But there is no dispute over here. It's pending at assessment level. You can still get a favorable order. If the case has been set aside by the ITAT for a proper opportunity, asking let it be heard again, then in that case, you can come under the scheme as long as you pay the tax on the main assessment. Why this is there? As our DCITs are very rightly said, penny stock cases, very often we used to go get a set aside. We used to go to the appellate authorities, we'll get it set aside to the assessing officer. Then again, that same circle will start. It will go saying that opportunity to be heard. Every year it will go. Department are taking a stand irrespective of whether opportunity given or not. We will make the addition. Assessee is saying opportunity should be good, should be good. So here they are said to give you finality on that matter, even if it is set aside for your relooking and proper opportunity, you can still come under the scheme. What if parallel proceedings? I think I've already clarified this. Such cases, yes, I've already touched upon the first point. If I'm going very fast, don't worry. I'm only moving the slides so that I cover issues. I'll be happy to share the PPT with everyone. So don't worry about that. But I'm just going fast so that I can try to cover more issues. Okay, now a very important question. Where quantum and penalty is pending, can the assessee apply only for penalty? So though quantum and penalty are two separate matters, they're intrinsically linked to each other. So therefore, if you come under the scheme, it will not be possible for the appellant to only apply settlement for the penalty appeal only when the disputed tax is still pending. So therefore, in those cases, you have to appeal for both. I cannot say I have settled the quantum and penalty alone, I will fight it out. Like that, you cannot say. So therefore, you have to come for both under the scheme if that is the case. One very important thing, assessment order has been passed. Many people have asked this. Assessment order has been passed, but there is an error apparent on record. I have already gone on appeal against the assessment order as on 31st January 2020. It is pending. but then only the scheme has come to light and there's an error apparent on record. So can I correct it under section 154, or will the scheme only the old order which was passed on which I went on appeal be eligible? Department have clarified where there is a error apparent on record, you can file a rectification under section 154. And once that rectification order comes, you can then apply under the scheme. So if there's any mistake in your order, please file 154 petition, get it rectified, and then you go under the scheme. Of course, naturally, somebody asked, sir, I will come under the scheme, and then once the scheme finishes, I'll file appeal against the scheme, saying scheme is not done properly. You cannot file an appeal. You only have power of filing a writ. That also only in substantial question of law it will come up. Otherwise, you cannot challenge whatever order is passed as per the scheme. Additional grounds. I filed the appeal. Then subsequently, I am coming to light that the scheme has come. So additional grounds I am filing. So can it be covered under the scheme? Only if your additional grounds are filed by 31st January 2020, cutoff date. If it is filed by the cutoff date, only then you can come under the scheme. Now the most important question. This another auditor had asked me this. So I was very impressed with this thought. He said, sir, under section 68, they have made additions in my case. They have made addition under section 68 saying unexplained credit. Now I'm coming under the scheme. So now I'm coming under the scheme, I'm paying the amount. Can I add to my sources? Now I've come under the scheme, whatever addition they have made, can I add that as my capital, saying that so much income has been admitted? It's a very, very good question, sir. But it has been clarified that it is not an amnesty scheme. You are simply settling it. So you are not admitting that it is part of your source. Department is not saying it is part of your source. Similarly, they are not saying it is not part of your source also. It's only to settle the issue, that's all. So there cannot be other adjustments in your books of accounts because of this scheme. So I think with this, we have covered all the FAQs and all the major issues. Thank you so much for a patient listening. We have already exceeded time. Maybe we can take a few questions, sir, before we wrap up. If there's any questions, I think I've covered almost all the major issues, all the doubts that they're having. Of course, I've given my contact details over here. So if anybody wants the PPT, you can feel free to just drop me a message on WhatsApp. My mobile number is here, email ID is here. Feel free to drop me a message. I'll be happy to share the PPT with you. And any other offline discussions also, you can feel free to reach out. But if there's any few questions, maybe we can take up, sir, here. I hand over the proceedings to the able hands of the coordinators. Vamsi, sir.
Sir, one of our member is asking, there in Schedule A, we have to mention the total income, whether the total income includes agricultural income which was exempted, or we have to not to disclose that agricultural income. That is what they are asking.
You did not disclose, sir. It is only whatever is your taxable income. So if you, but either way, it will not make that much of an impact to you, because that total income is only for the mere purpose of disclosure. The ultimate figure, what is important is disputed tax. So your total income, you need not, agricultural income should not form part of it. So you need not disclose. But if you want to show also, you can show, don't worry about any repercussion. Nothing will happen.
Sir, one of our serial member is asking,
yes,
depreciation was wrongly calculated before assessing officer accepted additionally paid tax along with interest, but it was not intentional mistake. AO has charged penalty. We again lost CIT appeals, but not appealed before IT80. Can I come under this scheme?
Jivaratnam, sir, this is a pure question of cutoff date. That is why repeatedly I said cutoff date. That by 31st January 2020, if you had time to file the appeal, even if you have not filed, you said we have not filed before IT80, so you have not filed. But suppose you had time. What is time? 60 days in case you have got a CIT appeals order. Assessing officer to CIT appeals, 30 days time. CIT appeals to IT80, 60 days time you have. So if the time limit, 60 days time from the date of receipt of the order of the CIT appeals, if that time has not expired, even one day you have as on 31st January 2020, then you can still come under the scheme. But if you not come under the cutoff date, then I'm sorry, you will not be eligible for the scheme, sir. Can we avail the scheme on one or more issues under the appeal and not on all issues? No, sir, cherry picking is not allowed. That is why I gave you that example where I'm having 3 additions. 1 addition alone, I want to come under the scheme. 2 additions, I want to fight it out. You cannot choose like that. You cannot choose. If you come under that assessment order, full assessment order, you have to either come under the scheme, or full assessment order, you have to fight. That is what it says.
Sir, tax was paid.
Yes.
Penalty provisions are pending. So then whether we can go for this?
So that again, that cutoff date, if it is pending as on that cutoff date, you can definitely come under the scheme. If it is not pending, then that scheme opportunity will not be there, sir. One more question has come. I'll just read that. If one of my case assessment has completed under 143.3 and assessee has gone to appeal and lost, we further went to CIT appeals and further we went to ITAT appeal and High Court. Presently, the case is pending in High Court. Whether I need to fill all the details of CIT appeals, ITAT appeals, High Court, or directly we can fill only High Court. The case relates to assessment year 98-99. I don't have much information regarding CIT appeals, ITAT, and date of filing of appeals before CIT appeals and ITAT. Sir, where it is pending before High Court, only if you give the High Court details, it is enough. You need not fill full details for CIT appeals. But naturally, some figures you may have to pull out from there. So whatever ITAT order you have, if you have the latest computation, you use that, or otherwise go to the department, ask your assessing officer to give you the computation for that year and fill out using that, sir. But only High Court details you need to fill. You need not fill all the other information.
Members, if you are having any further questions, you can drop it in chat box, or you can unmute your mic and you can directly ask the faculty, sir.
Sir, this is Jeevaratnam.
Yes, sir. Yes, sir.
Regarding that depreciation CIT appeals, you told me that date of 31st
Yes,
January is the cutoff date.
Yes,
Actually, can I appeal to ITAT now and then go for the scheme?
no, sir. But if it was eligible as on 31st January, then you could have done it. Otherwise, everyone will file appeal after the scheme was announced. So they had to set off a cutoff date. So that is why they have put the day before they announced. 1st January, 1st February in the budget, our Honorable Finance Minister, she announced. So the day before the budget was set as the cutoff date. That is the logic why 31st January.
Actually, at the time, I didn't receive the order. After January only, we received the order. But
this is a good question. So suppose the date of the order, order dated before 31st January, then you can go on appeal. So you can go on appeal. But suppose it is dated after, then in that case, unfortunately, you're not covered under the scheme.
okay, sir. Thank you, sir.
Is it possible that department has liberty for going for appeal for condonation of delay? Technically, no, sir. They cannot come under the scheme. The cutoff date is universal, both assessee and department. Has the department started issuing final certificate Vivad se Viswas scheme and accepting completion? So far, I have not seen, sir. At least in the cases that I am handling, it has not yet been issued. In Chennai, they have not issued anything. I think they will start issuing only after 31st December. That is why they have given that extension time for March for the tax payment, not only for us, but for department also. They are also under a lot of pressure. So for them to give them time to process it, they have given time, sir. So I think we have covered all the questions, Vamsi, sir.
One last question.
Yes, sir. Yes, sir.
Abhishek Murali garu, this is with respect to that rule 9 with respect to unabsorbed losses and depreciation. They have given 2 types of computation, right?
Yes, sir.
The first type of a computation which you have already detailedly discussed, that the disputed loss or depreciation, you calculate the tax 30% and pay surcharge and cess on it, and you just carry forward the depreciation. And there is another mode of computation also, the rule 9 explains. Can you please throw some light on it?
I think that's a good question, sir. But as you very rightly said, that is very complicatedly worded, and there is
Yes.
some lack of clarity there. There is a vagueness. In fact, I must say that I'm part of the committee where we are giving feedback on the faceless assessment to
Yeah.
the finance ministry, and we have in fact communicated as part of that we want some clarity on this. So
Yes.
this issue has been raised, saying there is a
Right.
lack of clarity, be it the department side or assessee side also. How you are going to calculate the MAT credit carry forward in the scenario that you are saying, or how you will carry forward the loss? There is a lack of clarity, sir. So you are absolutely right. There is a vagueness to it. So we are waiting the clarification on that. I'm sure we should get in a matter of time.
Please put all your efforts to get it in next FAQ at that point.
I am hoping one more FAQ, at least they will come.
Yeah, please
31st December. So I'm hoping we'll get a clarification there, sir.
Yeah, please do it. Thank you.
Thank you.
Sendil sir, may I ask a doubt to you, sir?
Yeah, please tell me.
Sir,
Please tell
regarding
me.
some of the cases prior to assessment year 8-9,
Okay.
how will you get that BSR code, that information, sir?
No,
Because
that's
I
what,
know for department also
recently,
they are struggling. Yes,
yeah,
sir.
sure. Recently, that DTRT Bangalore has conducted one seminar on demand management module. In that module, they have given a path with respect to ITBA help desk also. Suppose if we have any difficulty, we can keep complaint we can log on complaint in the ITBA help desk for universal pulling of that SIN number with respect to that challans.
Okay.
So they have given path on it. Only thing is the assessing officer has to upload the manual order with respect to that assessment year, then log a ticket. Then ITBA help desk will definitely help us to get that challan and whatever the details what you have discussed in that thing. So that we will get it.
Okay.
Only thing is with respect to that financial year, assessee should have ready with his manual assessment order. Assessing officer will be seeking of it. So once if you give that manual order, then every detail will be there. After uploading the same, assessing officer will log a ticket and he will definitely help you with respect to that SIN number, everything.
Great. Thank you so much.
Yeah.
So if there are no further questions, I request our branch secretary, Arun Kumar, to please carry on the further proceedings. Arun, are you there? Sir, I think Arun has just logged out due to network issues. So I request Ongole branch Vice Chairman K. Rajendra Prasad Garu to give vote of thanks. Sir, before going further, a small, okay, it's only a thanks. Okay, sir, you can say vote of thanks, sir. Thank you.
Friends, it is my proud privilege to propose vote of thanks. First, on behalf of Nellore branch of SIRC of ICI, Ongole branch of SIRC of ICI, and Tirupati branch of SIRC of ICI, we express our sincere gratitude to the today's chief guest, Dr. S.K. Sendil Kumar Garu, IRS Deputy Commissioner of Income Tax, Nellore, for accepting our invitation, sparing his valuable time to address our members during the inauguration of the virtual CP seminar. We also thank today's faculty and secretary, SIRs of ICA, CA Abhishek Murli Garu, who has nicely dealt with the statutory background of the scheme, eligibility to avail the scheme, forms, FAQs, case studies in a lucid manner. We thank Abhishek Murli Garu for his wonderful, vibrant and mesmerizing presentation on Vivad se Viswas scheme. Majority of the members are still stick on to the presentation. We also thank our Nellore and Ongole branches ex officio member and our SIRs member CAT Chinamastan Garu, who is available 24/7 to all our members. Nellore branch chairman CA I Vamsi Krishna Garu for his efforts in organizing the seminar by bringing all the three branches into one single platform. Ongole branch chairman CA Madhav Sachinan Garu, Tirupati branch chairman CA Sudarshan Naidu Garu, MC members, past chairmen of all the three branches, senior members, dear professional colleagues, branch staff, press and media, and all others for making the virtual CP seminar a grand success. Thank you, one and all. Jai Hind, Jai ICI.
Yes.
Over to chairman, sir.
Thank you, sir. Thank you. I hope the session has been closed right now. Thank you for your wonderful participation. I also personally thank all the participants who were present throughout the session, and I especially thank Senthil Kumar sir. He was present throughout the session, and he has gone through the entire session. I also thank our Abhishek Murli sir for giving the wonderful presentation to all the three branches.